Can you please look up this site?
See if we can figure out something.
All right. Good afternoon.
Good afternoon. How are you?
Well, how are you?
I'm good.
All right, Ms. Hardy,
Yeah.
I need to see you in the camera. Get ready to call your case.
Okay.
I can't see your face, Ms. Hardy. I'm sorry.
Oh my God.
It's 241033 LT, Bloomfield on the River versus Kamari Hardy. Appearance to the record.
Good afternoon,
It's
Your
not
Honor.
Kamari Hardy, it's Keisha Hardy.
Keisha, I'm sorry. They got it wrong on the paperwork. Go ahead, Miss.
Carrie Zanin on behalf of Plaintiff, Your Honor.
All right. Oh, they have Lakeisha Hardy. I'm sorry. I should have said both names. Kamari Hardy, Lakeisha Hardy, and all other occupants. State your name for the record, ma'am.
Keisha Hardy.
All right. We're here for a pre-trial. It was introduced before step final pre-trial and bench trial for Judge of Record, Jay Brewery, after 8:30. How we proceed?
Judge, at this time, I'm showing that rent is due in the amount of $529, court costs of $216, a total rent retained of $745. Originally, when this was before the court, there was complaints that they did not owe any of the rent because there was an abatement by Mishta. There was an abatement letter that was sent out by Mishta on May 29th, 2024, indicating that they had paused payments to the landlord because the property was not in compliance. However, that notice also is very clear that although the payments are stopped from Mishta to the landlord, the tenant must continue to make their portion. To date, they are now in compliance with Mishta. Mishta has made all of the back payments for June, July, August, and September in the amount of $999. So 4 payments of that. The portion that I'm claiming that is due is the tenant's portion. It does not include late fees, as I asked the client to remove the late fees because this was a Mishta issue between Mishta and the landlord. This is just her portion, the $529. So I asked that a judgment of as delineated on the record be entered with a writ issue in 10 days.
Nope, that's false information. I don't have a portion.
It's a portion that's from before, and the ledger is very clear.
I did not have a portion. My portion before was $239. That was paid all the way until they stopped until I gave them notice, which was already given to the first lady. So I'm not sure if they transferred all the information over to all 3 of you different attorneys.
They did.
Well, hold on one second.
Yeah, Jesus.
So,
y'all trying to
Ms.
come
Hardy,
over.
I think what they're trying to get at is that Mishta said you still had to pay and they'll cover their end. Did you make the payments that Mishta said you were supposed to make?
No, that's not. No, that's not what Mishta said.
Well, there's a letter.
Right.
And so during the period of them trying to fix whatever they messed up, they're not imputing what happened between Mishta and the landlord. That's not your issue. So we're not going to focus on that. But they did say, while we're working this out, you still need to come up with your portion.
I did not have a portion. That's what I'm trying to get y'all to understand. At that time, I did not have a portion. My stuff was turned down to 0.
Let me ask you this.
Am I finished speaking before you interrupt me?
Well, Ms. Hardy, I got to understand what's going on because I'm the judge.
That's what I'm trying to help you understand, but you're interrupting me.
Hold on. But Ms. Hardy, maybe I'm interjecting because there's a question that could help resolve this. I'm not saying quicker, but do you have something saying that you did not owe, like a letter or something saying you did not owe your portion during that part?
I gave that to them. That's what I said in the beginning. I gave all of those documents. That's how they knew about the the Section 8 stopping that. I gave them the documents. Every document they have came from me, not nobody else. I gave them all the documents that they needed. For day one, I emailed it to the first attorney, which was a lady. Then after that, there was a man. Then after that, now it was another man. And then today there's a woman. I have already given this documentation. That's what I'm saying. I've already gave them the document from Mr. showing that we no longer receive, my daughter no longer receives SSI. That was the income for the home, besides the food stamps. Once I gave Mr. that information, they then sent me a notice in the mail saying that my portion was now turned to zero and they will be doing the whole entire portion for rent. I didn't have
That's effective.
I did not have
Okay.
a portion within that time. So there's no way that you can say that I owe anything,
Well,
owe no
okay.
$500 if I didn't have a portion at the time.
Sorry, let me calm you down because I know nothing about these cases. So when I ask you a question, it's to fill me in so I can best make the situation fair and true. That's it. I understand you're frustrated, but I'm coming in trying to understand the game. And
Understand?
that's both you and Ms. Cox's job, you and Ms. Xander's job to fill me in. So just relax, calm down.
I'm relaxed. I'm just saying, like, I'm steady trying to tell everybody this is the fourth time we done came for this same situation, which should have been resolved day one, or if not even day
Okay.
one, day two. We done came to court four
Okay.
different times, and there's never been a resolution for the situation for them to understand that they didn't even send me a ledger of the payments, which then backs up my statement that they
Okay.
brung,
So,
that's
Ms.
broken
Xander,
on the river, applied and sent to my mailbox, showing and proving
okay.
that there is no back rent owed for anybody. It's been already
All right,
paid.
Ms. Hardy, thank you. Thank you, Ms. Hardy. Ms. Hardy, thank you. Ms. Xander, go ahead.
Judge, we actually sent to Miss Hardy a copy of the ledger, and the proof of service is dated August 16th, 2024. It was served to her house at 309 South Telegraph Road, Unit 15, Pontiac, Michigan.
And it wasn't on the 16th because that's the day we had court.
That was
You
the
can't
day we
deliver
mailed
the
it
same
out.
day.
My office mailed it out to you, Miss Hardy, that day, as instructed by the judge. And
Okay.
Judge, as to the
All right.
letter from Mishta, it is the letter from June, and it's very clear in paragraph effective June 1st of 2024. As effective date, Mishta will stop rental payments. The participant must continue to pay their portion of rent to the landlord.
So if
Judge,
I don't have a portion, what am I paying?
Your portion is $239. As for
No,
those
it's
are 2
not.
months.
You got the paperwork,
All right,
so you know that it says zero.
All right, so Ms. Hardy, this is what I'm gonna do. This is like your last shot. I'm gonna give this 30 days. Well, matter of fact, I'll give it a couple of weeks because it shouldn't take you that long. We'll come back on the 19th. You need to provide any proof to Ms. Xander, Attorney Xander, that your portion was zero. Because this letter from Mr. who's paying for it says you still got to pay your portion, right? So we understand that. We understand that. I don't need to not, I'm talking. We understand that. Now it's your job to bring evidence to Attorney Xander saying it was zero. Somebody else said zero. If you can't provide it, I got to grant their motion.
It's already been provided. That's what I'm telling y'all. It's already been provided. That's what I'm telling y'all. Day one, it was provided. It was emailed to Jen. Emailed to the lady named Jen.
So let me stop you right there. Ms. Hart, let me stop you right there. Did you send an email?
I did personally the same day.
Okay, let me stop you right there, Ms. Hardy. Let me stop you right there. Let me stop you right there. Send an email to Ms. Xander. Period.
Okay, yeah. Can you provide me with your email and I will send it to you?
Yes, it's C-A.
I'm about to say, let me give you a date.
Just a second. Let me get a
writing room. Right.
Just a second. Let me get a writing pencil.
I'll see you on September
19th.
We'll come back to 16th. It don't even take that long. It's an email. So I'll see you
Great,
next week.
Okay, perfect, Judge.
Same time.
Same time in the week. What's your email, ma'am?
It's
Hold on 1 second. Hold on one second. All right, go ahead. Breakout room.
Oh, thank you, Judge.
Go
Excuse
to breakout room, Ms. Hardy.
Yes, Judge, good afternoon.
Yes. Good afternoon. What case are you here on?
I am here on case, two cases, I'm sorry. One ending in 776 and the other one ending in 1033 for the Cox firm.
Okay. I don't see Maya Triplet and I don't see Kamari or Lakeisha Hardy.
I don't know, I believe that Ms. Hardy had legal aid. I'm not sure if that's still the case, Your Honor.
Yes, I don't even see legal aid on.
I don't believe I've had any communication with any legal aid, or we have since the last hearing.
This next matter, 241-033 LT. Bloomfield on the River versus Kamari Hardy, Lakeisha Hardy, and all of their occupants appearance to record.
Good afternoon, Rania Haddad, PH 497 on behalf of the plaintiff.
All right. So I don't see Kamari or Lakeisha Hardy on Zoom. So I know she was supposed to email proof to Attorney Zanin regarding defendant not owing money on this case or in this case. Did Attorney Zanin share any notes that she received anything from Ms. Hardy?
So I do see that my client has waived some fees, but the balance still due and owing is $529. So the balance is not currently zero and the defendant is not present. So we would be seeking a judgment today.
Over time to submit that proof. So I will sign the judgment for
And how would the court like that submitted?
we have an order right here. You said the rent to retain possession, how much was it?
$529, Your Honor. That is not inclusive of $190 in attorney fees and costs. So the total amount of redemption would be $719, correct?
All right, so I'll sign the order. It says the plaintiff can apply for an order evicting the defendant. The defendant does not pay the plaintiff or the court the amount due in 2D or does not move out, we'll give her 10 days.
Yes, Judge, September 26th.
That's September 26th.
Thank you, Judge.
So we're all set. Thank you.
Stormy nights don't stay. From the moment that we